Thank you all very much. My name is Judge Pat DeWine. I'm a judge on the 1st District Court of Appeals in Cincinnati. Before that, I was a trial court judge, so I've served at both the trial and the appellate level. I'm running for the Supreme Court because I care deeply about the direction of our state, and in particularly about our court system and what the proper role of the court is. I'm someone who believes the role of the court ought to be to apply the law as it's written, not to be an activist judge who goes out and imposes their own personal views, not to be someone who tries to shape the law in the way they think it should be, but to honor the system that our framers created when they adopted our Constitution. And that is a limited role, a limited but important role for our judicial branch. So make sure the other branches stay within their constitutional boundaries and to defer to the other branches of government as long as they operate within this boundary. And I think one of the biggest problems we have in this country is that we have too many activist judges who don't understand what the role of the court ought to be. I'm getting the sign. So I just pledge to you on the Supreme Court, I will carry out that role. Thank you.
Good morning. How are you? Everybody good? You ready to come back at this again now? My name is Coleen and I'm running for the Ohio Supreme Court. I'm a judge. I've been a judge for 9 years up in Lake, Geauga, Ashtabula, and Trumbull counties. Folks in my district we come from Tea Party Central actually, with Matt Lynch, Tom Zalestowski, Sadie O'Brien, Kim Laurie, and so I really do believe in the Constitution. I've spent my entire adult life, especially since I've been a lawyer, defending the Constitution. I'm also a lot older than I look. I have a 28-year-old son. I always get that. Well, thank you. I'll thank my mother for that. I concur with my colleagues and everybody you heard this morning. We need not to be activists. We need to be conservative. We need to follow laws written. We need to honor both the state and the federal Constitution. But as you know, a lot of politicians get up and they can talk the talk, but they can't walk the walk. I have a long and extensive history, and you can look at my cases. I'm pro-Second Amendment. I'm a licensed carry conceal license holder, and my husband's a Marine. We have 3 children, and I'm Catholic. And I want your vote for conservatism and for the Ohio Supreme Court. We need to keep it conservative, but I walk the walk and I talk the talk. Thank you very much. Coleen Mary O'Toole, the right tool for the job.
Maurice? Thompson. Maurice is going to bring some questions forth for the next few minutes. We'll have some, hopefully if we end up with time, we'll have some questions from you all, but we want you to listen intently to the answers and the questions. So thank you very much, and this is Maurice Thompson.
Thanks. Maurice Thompson. I run the 1851 Center for Constitutional Law. I know a lot of you. I've worked with a lot of you in the past, and I'm happy to be able to ask Pat and Coleen a few questions. The Ohio Supreme Court is important to all of us. As many of you may know, only about 30% of voters, according to some estimates, who show up to vote for president and other things, actually make it all the way down the ballot to vote on judges. Now, that means that your vote matters more than it does for president, for senator, for anything else. So your ability to educate yourselves and have influence on this kind of election is actually greater than almost any other kind of election except for perhaps your local elections. So bear that in mind. Also bear in mind that the Ohio Supreme Court is the last line of defense. When we have governors or legislators or administrative agencies in Ohio that overreach their boundaries, it's ultimately the Ohio Supreme Court that's going to enforce the Constitution and limit government. So my questions are targeted towards that. When these folks go to other special interest groups to speak about whatever issue that interest group is, it might be insurance, it might be pharmaceuticals, it might be the Chamber of Commerce, are they pro-business, are they not? They're going to be asked questions about those issues. Our interest, our special interest, is the United States Constitution and the Ohio Constitution. We're a special interest group against special interests, essentially. So we're going to focus only on constitutional jurisprudence. We're not going to talk about criminal sentencing. We're not going to talk about whether you're pro-business and what that means, because they're not going to get these kinds of questions when they visit any other special interest groups over the course of the next year, however long it may be. So, with that said, let's dive right in. One final caveat. There is this judicial canon of conduct where there are some limitations on the kinds of questions that judicial candidates can answer. All the questions I'm going to ask are questions that they can in fact answer. So I'm not going to be asking about specific cases that could be in front of any court right now or that could come up in the future. And if I attempt to do so, they won't be able to answer. If there's time for you to ask questions at the end, bear that in mind also. They may not be able to answer that kind of question, but they can certainly speak to issues, their views, their political philosophies, and how they've implemented those philosophies, most importantly. So, the judges have already introduced themselves. Let's move straight into judicial philosophy, because that's what we care about the most. So I'm going to ask each candidate, and I'll just rotate. I'll start with one first, and then the other person will go first the second time, so that the other person has time to think. I will also say that I do this forum about every 2 years with Ohio Supreme Court candidates, and typically I give these questions ahead of time to the candidates so they have time to contemplate and think about what the best answer is. So these two are very brave. They do not have these questions.
I didn't know I was allowed to get the questions.
Well, this came together yesterday. Glenn called me yesterday.
Okay.
So there's no advance notice. We're flying from the seat of our pants here. So if their answers aren't perfect, you'll bear that in mind as well.
You won't hold me to all the case citations.
I will hold you to the case citations, just like you would me. Maybe I get some extra oral argument time the next time.
Maurice, before we start, just so everyone's clear, there's actually 2 seats on the Supreme Court that will be up in 2016. So I'm actually running for Paul Pfeiffer's seat, and Judge O'Toole is running for Judge Lansing's seat, who's leaving. Judge Fisher
we're not
spoke this morning.
Right.
Is running as well, just so everyone understands what the landscape is.
Is stepping down.
The Ohio Supreme Court has 7 judicial seats. 3 will be up in 2016. The Chief Justice O'Connor will be running for re-election. She typically wins in landslides. Presumably nobody's going to challenge her in her primary. I may be wrong about that. The 2 other seats that will be open will be Lansinger and Piper. I expect Lansinger will retire before the end of her term, and somebody will be appointed and then running as an incumbent. I may be wrong about that. I expect that Justice Piper will not retire before the end of his term, because that's kind of it's kind of a political game that gets played with judges, and Justice Piper has a tradition of not playing those kind of games. So I expect that Judge DeWine will be running for that open seat when Justice Piper does not retire. Okay, judicial philosophy. If you can each explain your judicial philosophy, and equally importantly, how you carry that philosophy into execution. And specifically, we're talking about constitutional issues, the issues of limiting government and advancing constitutional rights. And I'm then going to drill down and ask you to identify a judge or a legal philosopher that is not completely unrelatable that kind of typifies your philosophy. And in doing so, you can choose any current member of the Ohio Supreme Court, any current member of the United States Supreme Court. I think that the folks in the audience would know most of the Supreme Court members well enough that would help give them a compass to relate to what your philosophy is. So, Judge O'Toole, what is your judicial philosophy, and how could you implement that philosophy upon the Ohio Supreme Court?
Well, presently I'm on the appellate court, so we do get several constitutional cases. I have a body of law about 1,500 cases deep, in where I have ruled on multiple constitutional issues. My constitutional perspective is, of course, conservative, right? I mean, we follow the law as written. But I would like to go a step further than where Judge Fisher went this morning, in that he says that you follow the law, the statute as it's written. And I concur with that position, except if it conflicts with the Ohio Constitution or the U.S. Constitution. So when I look at a case, I have to check all 3 boxes to make sure that that rule complies. I don't think you should use legislative notes. I don't think we should use foreign law. But in reality, small government footprint is consistent, right? If it's close, it always goes to the people or the individual. And as I said, I walk the walk and talk the talk, and I have several cases, especially in the area of Second Amendment rights or First Amendment rights, where I've actually challenged, legislative statute.
Good. And is there a particular legal philosopher, is there a particular book also, by the way? Feel free to cite a book. Is there a book or a philosopher or a judge that has particularly informed your thinking, and why?
Well, that's kind of interesting. Legally, I'm a fan of Justice Scalia. I think he's intellectually about as good as it gets. And the cool thing about truly being conservative is it really isn't about an outcome, whether the criminal goes free or he stays in jail. It's about the analysis, it's about the formula, it's about the logic that goes into it, and being consistent to the lodestar, which I feel is the Constitution of the United States and, of course, the state of Ohio. So he would be my favorite guy. Sometimes it's interesting because, especially when we're dealing with 4th, 5th, and 6th Amendment rights, sometimes he says, hey, government, too bad you have to let the guy go, right? Because you violated the rule. Our founding fathers have set up the Constitution because they very much realized at the time that the government is a much bigger threat than any one individual. And so I honor that in my philosophy and in my writing as well. Now, my favorite book is kind of interesting because it's really not a legal book. I do a lot of technology stuff. I really am open and aware that the world is changing around us with the advent of information and the internet. So I really like that the world, the world is now flat. So I read a lot of stuff around technology and how we as a justice system can still preserve our constitutional values and enforce the Constitution only more efficiently and more effectively based on real time. We are not far away from being able to put all of my decisions into a database, and you're going to be able to predict within a reasonable degree of probability how I'm going to decide a case. Okay, data, marketing data, how you figure all that goes. I mean, those silly things that show up on Facebook, right? You're like, how'd they know? How'd they know I was just looking for, hardwood floors, right? So we need to look at data, and we need to look at that in regard to our Constitution and really try to make the Constitution mean what it says in light of an ever-changing informational world and technology. And I believe that's transparency, and I believe the Constitution requires transparency of government, and I think everything should be out there, and I think you should be able to ask me questions. Because you know what? Those questions are probably already answered in my writings, and you're going to be able to find out the answer anyway, so why shouldn't you be able to talk to me about them? So, that's it.
Very good. Judge DeWine, the same question to you. What is your judicial or legal philosophy? How do you implement that as a judge? And then I'll ask you about a book, author, justice on the court whom we can use to kind of pin you down.
I think, this is something I care deeply about. In fact, I teach students at the University of Cincinnati about our constitutional system and about our court system. I think my judicial philosophy comes from the structure of our Constitution, right? Our framers created a constitutional system where we had 3 branches of government, 3 co-equal branches of government with checks and balances. And they did that because they were concerned about government power. And they were concerned about the government having too much power. And they didn't want any one branch of government to have too much power. And so they created this system, a constitutional system of checks and balances, so that the branches of government could keep the other ones in check. So that's just kind of backdrop to think about this stuff. And so I look at the role of a judge, the role of someone who wants to be in the Supreme Court, as one is you have to apply the law as it's written. Our job in this constitutional scheme is not to go out and to try to be legislatures. It's not to be philosopher kings. It's to apply the law as it's written. And so, as long as the other branches of government act within the boundaries of the Constitution, then we practice judicial restraint. We give a lot of deference to those other branches of government. But if they exceed those boundaries, if they start infringing on, for example, individual liberties that are guaranteed by the state or federal Constitution, our job is to be the protector of the Constitution and to be that check and make sure that those other branches of government don't go beyond their boundaries, don't infringe upon the rights that are guaranteed to you as people. When I look at the Constitution, how I read the Constitution, look, I don't think the meaning of the Constitution changes. I think it meant what it meant, what those words meant to people at the time those constitutional provisions were enacted. So if we're looking at the 14th Amendment, for example, I don't believe in some kind of vague notions where the meaning of those provisions changes over time. I think we look to the words and to what those words meant. So I have kind of an originalist understanding of the Constitution. Would probably be the way you characterize my constitutional philosophy.
And then a current justice, Ohio Supreme Court or U.S. Supreme Court, and perhaps also a book that typifies your specifically legal or judicial philosophy.
I think that I probably, when I look at the U.S. Supreme Court, the two justices who would have the philosophy closest to mine would probably be Justices Thomas and Scalia. They both have an originalist view. They both are very focused on the plain meaning of the statutory, or whatever it is, whether it's a contract, a statute, or a constitution that they have in front of them. So probably those two are the closest. I don't know if a book. I would certainly say that if you're looking at just how you should apply, what a judge's role should be in applying statutes and applying the law, I think that the book that Justice Scalia and Brian Garner wrote recently, Reading Law, I think it's called, came out like 2 years ago, is a very good book on construction of statutes in the Constitution.
Thank you. And we'll stick with you this time. I'm going to jump ahead a few questions because you mentioned deference. So I have a question about that, and so we'll just do that now. The Ohio Supreme Court has undergone many iterations, and most of the people in this room have seen those iterations. Up until about 2004, the majority of the court was dominated by candidates who were supported by labor unions and who were very aggressive in striking down tort reform, the DeWine decisions about school funding being unconstitutional. In about 2004, that pendulum began to swing the other way with more Republican candidates. And you may or may not know that since about 2004, the court has been either 7-0 or 6-1 Republican. In the process of doing so, there are questions that are very valid about whether the court has swung too far in favor of judicial restraint and now does not strike down enough government actions instead of striking down too many, which some may think of as a different kind of activism. So my question for you is about judicial deference. What level of deference is owed to the legislature? What level of deference is owed to a local government or an administrative agency? Is it the same for all three? Should it be different for all three? And particularly in light of the court's recent rulings that the statutes are to be presumed constitutional in Ohio and a challenger has to prove beyond reasonable doubt that a statute is unconstitutional. Is that level of deference warranted? Should it be less?
The level of deference that the court gives to a governmental action should depend upon the area in which the government is acting. So if a state government, for example, the Ohio state government, is acting within an area that the Constitution prescribes that the state government may act, then we should give them a lot of deference. But that doesn't hold true when that government exceeds its constitutional boundaries. So when a state government starts infringing upon individual rights, for example, if a municipality in Ohio passed legislation that violated the Second Amendment, that violated someone's individual rights to bear firearms, then we're talking about individual rights that are guaranteed by the Constitution. So in those areas, we don't give deference to the decisions of state government. Rather, we have to do our constitutional duty and protect the individual rights that are guaranteed by the Constitution. So I think it's really it depends upon whether or not that state government is acting within their constitutional boundaries. Maurice is kind of a technical, well not technical, but it's kind of a lawyer issue. It's about the language the Supreme Court has used to describe the level of deference. And it has said recently that we presume a statute is constitutional unless it's shown to be unconstitutional beyond a reasonable doubt. Now, I can't say what standard deference I would use in my case, but I think that we have to be skeptical of that kind of thinking, because if you really believe that the role of the courts is to protect individual rights, then to say that someone to apply a standard that's really appropriate in a criminal case is questionable. I think the court needs to think seriously about using that standard.
Let me pin you down just a little bit further on that issue. So the challenge comes in not with what you do when a statute is clearly violating constitutional rights, but how you actually determine whether it may be unconstitutional, which is a much harder issue. And currently, the Ohio Supreme Court has a heavy thumb on the side, if we have a scale, on the side of government and against the individual taxpayer, property owner. Is that appropriate? Is that level of tipping the scales in favor of government appropriate, or would you apply a different standard?
Again, I think you have to ask two questions. I think before you get to the standard, you have to say what area is the legislature acting. There's certain areas the legislature has broad discretion because the Constitution gives that authority to the legislature. So in those areas, you have to give broad deference to the legislature. In areas, though, when it's questionable whether or not it's acting within a power that's been given to the legislature, or when there's a question about whether or not it violates individual rights that are guaranteed by the state or the federal Constitution, then we shouldn't give that kind of deference.
Good, thank you. You're going to ask me really hard questions the next time I'm in front of you now, I know. The same questions to you, Judge O'Toole. What level of deference is appropriate to the legislature, administrative agencies, or local governments, particularly in light of some of the clarifications I asked for from Judge DeWine?
That's a really good question. And by the way, folks, 1851 and Maurice are one of the premier legal minds on the conservative side, not only in Ohio, but federal. This is interesting. I mean, it's real. I mean, I read his stuff a lot. Okay, so just FYI, because that is a good question, actually. So, and now, no, I'm not stalling. The reason, all right, so here's the thing about deference, okay? Again, I go back to my basic philosophy that it's got to check all three boxes, right? You can't have a law that doesn't comply with the Constitution because I give somebody deference, right? Because otherwise there's no balance, and it interferes in a larger justice system that encourages fair play, that encourages balanced playing field, right? So even though in that particular instance you may want to give deference, all right, in a close call, I personally feel that you really can't give deference in a close call. I feel the overriding body of the Constitution, both Ohio and federal, says due process, says equal playing field, right? So I'm not going to tell you what to do or how to do it or how the legislature should fix it. But I think if you can't check all three boxes, it makes absolutely zero sense to send it back for 24 to 48 months. So the next issue up is, well, we didn't say in our last case that it was the state, we didn't say it was the statute, we didn't name the federal Constitution, so it's got to go back down and bring that one back up, right? I mean, if I learned anything, we are moving too fast. Everything now is in real time, okay? People need answers to their questions. Okay, and they need them timely, because when you're in litigation, it ties you up. It ties everything up. It ties up your business. It can ruin your business. It can ruin your personal life. You've got people that are sitting around waiting 2 years for a divorce, right? So the law, even the statutes as they're written, says get to the heart of the matter, right? Get to the issue at hand. Don't keep, tiptoeing around things like, deference if it's only going to come back later and you're going to invalidate it anyway. Right? So I follow the Constitution. Every time I do the analysis, I check all three boxes. Now, being on an appellate court, or let's say the U.S. Supreme Court says differently, right? I am bound by that precedent of the U.S. Supreme Court. Okay? So I cannot just, if they give deference and I have clear federal case law, or, you know, even at the Ohio Supreme Court as an appellate judge, I have clear case law. My role is not to say, you know, sorry, John Roberts, it's too bad, right? I mean, that's way above my pay grade as a state appellate judge. I can write in there, though, excuse me, there's a gross inconsistency here, you know, there's something wrong. And I can pinpoint it in the decision without necessarily going against precedent. So every time I do a case, every time I look at something, property rights particularly, I look at all three boxes. Okay, and I think that the people always stand on an equal playing field with the government. They don't have to take second best. Thank you.
To follow up on that, you raised the issue of when there may be a conflict between precedent and the text of the Constitution, or perhaps even the spirit of the Constitution, in your opinion. If you are on the Ohio Supreme Court, you will have the freedom to decide whether to choose to follow that past precedent or to revert to the original meaning or language of the Constitution. When the two conflict, what is your view on what is the best approach?
Okay, well, the first thing I would do is look to federal law, because at the end of the day, federal law will pretty much trump state law, right? I mean, I have to adhere to, I have a U.S. constitutional precedent, and that's really the way you guys want it, right? You don't want me getting up one morning and just deciding I don't like people in blue shirts and I'm the judge and I'm just going to say so, right? I mean, our system of laws is set up to provide judicial restraint. We don't want to get far ahead of ourselves. But, I mean, again, I think I would have more freedom to look at the constitutional issues, because that removes one layer from where I am now. Right, where I am now, I'm subject to the Ohio Supreme Court. I'm not on there. I'm on a lesser court or an intermediary court. My role as an appellate judge is more of quality control right now over my district. I look at things, I analyze things, I see if the lower court made errors, and I write an opinion, and those are appealed to the U.S. or the Ohio Supreme Court. So I'm not going to change the way I look at cases, right? So check the statute, check the Ohio Constitution, check the U.S. Constitution. If there's no clear federal precedent, I would not hesitate to rule in that regard, because that's my process, and I've always been that way. Sorry. You get what you get.
And because you raised the issue, I will segue into another question that's a little bit out of order, but still relevant. You mentioned looking to federal case law. I want to talk about issues, Ohio constitutional issues. As you know, the United States Supreme Court has said over and over again that state courts are free to interpret their own constitutions as more protective of individual rights than the baseline federal protections. And that's true whether the language of the state constitution is the same, like ours on free speech or due process, or whether it's different, like our property rights protections, which say private property shall be held inviolate. That's much stronger than you see in the federal constitution. So my question for you is, in those areas, should state courts interpret their constitution as more protective when the two are co-equal? And I say this in the backdrop of a situation where over the last 10 years, the Ohio Supreme Court has essentially deferred to federal judgments on federal constitutional rights, on equal protection, on due process, even on standing, where there is no standing bar to stop us from advancing important cases that limit government. So in these bounds, what's your view on whether the Ohio Constitution should be construed as more protective than the federal baseline?
Well, if it's written more protective, then it should be, right? I mean, basically, if you think of, and when I teach, I'm an adjunct at Penn State, and I picture it as a giant bullseye, right? And our floor, or the farthest we can go, is our federal Constitution, and then we go inward, right? So I think that the federal law allows, as does the federal Constitution and the federal case law, for us to interpret our Ohio Constitution so far as it inside the floor that is offered under the federal Constitution.
Let me give you a specific example. The Texas Constitution's due process clause is the same as the United States Constitution's, but a couple weeks ago, the Texas Supreme Court, which is a pretty good Supreme Court, found that a number of occupational licensing laws that prevented people from earning a living violated the due process clause, even though it would not violate the due process clause of the federal court or the federal due process clause. So the court went above and beyond what a federal court would have done to use that language to protect its citizens' rights. Is that something that you're willing to do?
I'm willing to do it so long that it's written that way, right? I mean, if you have two statutes that read identical, right? Then I would look to case law. The two statutes are exactly identical.
federal case law.
Yeah, federal and, and state, right? But if I'm sure, at least the Ohio Constitution, they're usually worded a little bit differently, guaranteeing the same issues, that are in the federal Constitution. Does that make sense to you? So if the Constitution allows me to do that, the state Constitution, and it says that in there, clearly I follow it the writing, right?
Same question to you, Judge DeWine.
Yeah, I don't think the judges should hesitate to look to state constitutions and the guarantees of rights that are contained in those constitutions. I mean, I think one of the things that the 1851 Society has done a great job about is being part of kind of the national conservative movement, but the idea that conservatives ought to look to state constitutions as individual guarantors of rights. There was a reason that Ohio created a constitution in 1851. There were a lot. One of those reasons was that we didn't feel the constitution that we had at the time was doing enough to protect the people. Those rights in the state constitution are important. There's no reason, there's no legal reason that we simply have to defer to the U.S. Supreme Court when we're interpreting our own Constitution. We, as the Ohio Supreme Court, have the last word on what the Ohio Constitution means. Even if the words are identical to what's in the federal Constitution, as they are for some of the provisions, we still have the last word about what those mean in Ohio. We shouldn't hesitate to exercise that power.
Thank you. Just a few more questions. Do you get 15 minutes or so? Oh, well, we're at noon, but I'm going to keep going. Here's one that I think is very, very important, which is a very basic question. You probably don't get asked as often as you should, so we'll start back with Judge DeWine, and that is, why do you want to be on the court? And so we have some ways that I view the court as currently deficient. Are you a reformer? Do you seek to reform the court? Do you think it's great how it is and you want to keep it the same? If so, how do you want to reform it? How would you like to keep it the same? So what is the burning passion inside of you that's motivating you to join this court?
I want to be in the court because I care deeply about this stuff. I care deeply about the role of the courts in our society. And for me, if you want to make Ohio a better place, care about people's individual rights, if you care about creating an environment where people want to live, want to be in Ohio, for me, the Ohio Supreme Court is where I can have the biggest impact. We have to be careful. I'm not allowed to criticize individual decisions, or be careful to criticize individual decisions, at least that they come back up before the court when I'm on. There's certainly areas where I think the court has done a good job. Frankly, I think we have a court. If you've been in Ohio for a while, there was a time we had a court that was a very activist court that seemed completely unconstrained by the Constitution, by their constitutional roles, and looked at itself as kind of a super legislature. I frankly think our court's a lot better in that regard than it is now. I do think that there are a lot of areas for improvement in the court, and I think I can help make it a better place.
Can you specify what one of those areas might be?
I think I think the quality, frankly, the quality of legal analysis. Sometimes I think that sometimes the court could be more disciplined in the manner in which it does its job, and I think there have been some inconsistencies there. There's been some areas of the law where the court has kind of been all over the place, has not given people the certainty it needs. So I think there's a number of areas. I can't talk about individual cases, so I'm not going to do that.
Okay, and same question to you, Judge O'Toole. What is it that is motivating you to be on the court? Are you happy with where the court's at, or are you a reformer, and if so, how?
The reason why I'm running for the Ohio Supreme Court is because I'm passionate about justice. I have 3 children, and I grew up in my mom was single, there were 4 of us, and I just wanted to make the place better. I wanted to do better. I'm a reformer because I'm pretty much all about making sure things function, keeping the playing field equal. Regardless of you're poor, if you're rich, any of those issues. And so I'm passionate about keeping things open. I believe in the justice system. I'm a true believer. I think it's not perfect, but it's the best system we have. And I think I've been very blessed that God has put me in a place that allows me to run for this office. And I truly feel that that is something I was cut out to do. So that's why.
And do you think the court is doing an adequate job of protecting, advancing justice now, or do you want other certain areas where you want to see improvement?
Well, again, my frustration, I guess, with the Ohio Supreme Court, I guess you could look at my opinions to see where they've reversed me, because they have on occasion, got to be honest. But I think the biggest threat to justice and our justice system is not deciding the issues when they come before us, and deciding the issues on technicalities and other things that don't really get to the crux of what the conflict is, right? So if something's unconstitutional, let's look at it, let's do the analysis, let's have the parties brief it. Don't just send it back and make them come back again. So I think my issues with the Supreme Court are like any other. They're slow. Sometimes they don't get their cases out fast enough, sometimes they're not efficient enough, and sometimes they kick things out for reasons that have nothing to do with the conflict. And that's what I would change when I get there. I would consistently vote to get to the meat of the matter and not take things away or discard them and let them come back at a later date with more money, more expense, and more time. Thank you.
Thank you. And then my last quick question, judicial philosophy you talked about. I remember the primaries, the Republican primary debates of 2000, which were not nearly as interesting as today's Republican primary debates. Notice we're at no personal appearance insults so far up here today. So, last question. The question was asked, who is your favorite political philosopher? George W. Bush had a hell of a hard time answering that question and reverted to just naming Jesus Christ because he couldn't think of a political philosopher. We knew we were in for a difficult 8 years thereafter, and indeed we got a difficult 8 years. So this is not about what you do on the bench, but just so we know you personally a little bit better, what political philosopher, political thinker, or author do you most identify with? And I won't even make you explain because we're short on time. So give me an individual, a book, something that you've read has influenced your life. I want to know what you think about the purpose and the role of government in society and where you learned that from.
I go back to our framers, Thomas Jefferson, Paine. I think that those are kind of the political philosophers I would look to.
Thank you. And Judge Toole?
I hate to be redundant, but again, Thomas Jefferson, when our Constitution was created, it was a golden time for political philosophy. Okay, we had Locke, we had Paine, we have the signers of the Constitution, and it was like the Renaissance, right? We came up with the model, right? Our model of a tripartite form of government was genius, and it's sustained for many years. And so I would look to Thomas Jefferson. I also like the writings of Thurgood Marshall, actually. So that's what I do.
Good, thank you. And those are all of the questions apparently that you're going to get from me. My personal opinion is that either one of you would be an improvement to the court's current composition. The next question comes from the audience. Matt Lynch, former state representative, who has had some litigation up at the Ohio Supreme Court. Like Congress, actually, can you challenge the judicial codes?
Yeah, I'm still challenging the First Amendment on the judicial codes. Yes, I am.
Ask her about that at some point here.
I'm sure you're following it closely, Maurice.
Yeah, Maurice and I go way back to when we filed a small lawsuit against the governor over Medicaid expansion. So I want to make my point real quick because when Judge O'Toole spoke, she mentioned my name and Kim Laurie's name and Tom Z's name. Yeah, we sort of, our Tea Party Central up there, we have not endorsed in this race, however.
Oh,
so
correct.
We
Yeah,
want
I
to make
didn't
that very
mean to say
clear.
anything like that. No,
we have not endorsed anyone in this race. So my question has really to do with the lawsuit that Maurice helped me sign when he said, gee, you're the last state rep in town, you better sign the lawsuit against the governor. And I said, Maurice, you think that'll be a problem for me? That lawsuit was about the overreach of the executive branch taking away the authority of the legislative branch. So my question for these potential Supreme Court justices, I'd like to ask them, would they actually agree with that decision that upheld that ruling that the controlling board could actually take that authority away from the legislature? But they're probably going to tell you that they can't answer that question. So I'll just ask them to speak directly to the issue of the balance of powers, which are being shredded in Washington. And when we lost that lawsuit Maurice, the plain dealer called Governor Kasich's action an Obama-like move. So my question is, what do these candidates think about a governor that makes an Obama-like move when it comes to the separation of powers in Ohio?
Hey, Matt, could you tell them about that lawsuit and the content? Because they're looking, some of the folks there were looking, is this the one with the Medicaid?
Well, yes, Medicaid expansion was denied by the state legislature, and despite that denial of state, and that's the foundation of Obamacare in Ohio. So Medicaid expansion leads to Obamacare. So when we stopped it in the legislature, the governor, working with the Speaker of the House and the head of the Senate, frankly packed what was a board called the Controlling Board, Administrative Board, which overrid essentially the rule of the legislature. That our lawsuit was to challenge that action, and that lawsuit ultimately was, we lost that lawsuit in the Ohio Supreme Court. So it was a question surrounding separation of powers.
And you want to know?
So my question is, how do you folks view the necessity to defending separation of powers when you're coming to sitting on the Ohio Supreme Court?
Who do you want to go first?
I'll go.
I'm in favor of separation of powers.
We'll let Ms. Jones go first.
All right.
You know, I look back to what Ronald Reagan said. Ronald Reagan said that our framers created 3 branches of government because they knew that the greatest protector of individual freedom would not be any one branch of government, but it would be the 3 branches of government keeping each other in check. And Reagan said, that's why we have an independent judiciary, and that's why the judiciary must exercise restraint. I think those are words that a judge ought to live by.
Excellent. Yes, ma'am.
I concur with my colleague, Mr. DeWine, or Judge DeWine. I think you have to have separation of powers regardless. The question occurs is when you don't have separation of powers, right? And the impermissible delegation of powers within the executive branch through its agencies, controlling boards, all the ODNR, all the other stuff that happens to be affiliated with the executive branch. So I would concur that we look at restraint, we balance them, and we would resolve any conflict by keeping everybody in their corner, so to speak. Thank you.
Thank you. Well, we thank you both for being here today. Anytime you address a politician who wants a job, never use their last name or whatever's on top of it. It's their first name. They want a job. So thank you. Coleen, thank you. All right. Greg McDonald.